keep your hand phones on silent mode throughout the program. Thank you for your cooperation. One more minute. Welcome to the post-lunch sessions of the two-day Delhi Arbitration Weekend. The topic for discussion for this session is corruption in arbitration, knowing the unknown. Corruption in any system dissuades the belief therein. Likewise, corruption in any aspect of arbitration would render it futile. In this session, the panel would exchange its thoughts on corruption seeping into arbitral proceedings, be it in terms of arbitrability, allegation of corruption with respect to any party, counsel, arbitrator, witness, impact of corruption on the proceedings, award and the underlying contract, and corruption being used by a party as a defense in the proceedings. May I now request the chair and the speakers for this session to grace the stage. Thank you. We have the honor of having Honorable Mr. Justice Nageswara to chair this session. A man who has donned many hats in life full of varied experiences, Justice Rao has acted in a number of films and even played domestic first-class cricket. In his early days, Justice Rao, as part of his illustrious career, was part of 555 benches and delivered over 160 judgments during his tenure, which saw him pass some crucial verdicts over the course of almost 6 years. He enrolled as an advocate with the Bar Council of Andhra Pradesh in 1982 and practiced at the District Court in Andhra Pradesh High Court till 1994. He shifted his practice to the Supreme Court in January 1995 and continued till his directed elevation to the bench in May 2016. He was designated as a senior advocate by the Andhra Pradesh High Court in December 2000. Justice Rao also served 2 terms as Additional Solicitor General of India twice. On May 13, 2016, he became the 7th person elevated directly from the bar to the Supreme Court and retired on 7th June 2022. He is currently an associate member of 39 Essex Court. With Sir, we have our esteemed panel of speakers. Ms. Sapna Jhangiani is recognized as a leader in international disputes and has been recognized as one of the top 15 legal female lawyers in Asia by the Asia Legal Business. She was also named as one of the Singapore's top 100 lawyers in the A list published in the Asia Business Law Journal and has been included in Best Lawyers for several years for her arbitration and mediation expertise. She's a barrister in England and Wales, as well as a solicitor and advocate for the Supreme Court of Singapore. Along with her counsel work, she sits as an arbitrator and a mediator. She is also the chair of the CIR Singapore, vice chair of the ICC Commission on Arbitration and ADR, and an editor of Investor State Law Guide. Mr. Francis Xavier. Mr. Xavier is Rajah and Tann's Singapore's regional head of Dispute Resolution Group. A veteran in the field, Mr. Xavier has 33 years of legal practice and actively involved in cross-border commercial disputes in the areas of corporate banking, property, financial and investment-related claims. Mr. Xavier is recognized as a leading disputes lawyer and was recently named as one of Asia's top 15 litigators by Asia Legal Business 2021. He has appeared as counsel and has acted as arbitrator, both party appointed and presiding in a large number of arbitrations. Moving on to Mr. Nusrat Hassan. He is the managing partner of Link Legal and has more than 25 years of experience. He is a qualified attorney enrolled with the Bar Council of Maharashtra and Goa. He is also a qualified solicitor affiliated to the Law Society of English in Wales. He has created a niche in international arbitrations, having led arbitrations in India and Singapore for select clients. Honoring his expertise in arbitration, he was an invited convener of the core group of CII Task Force on Dispute Resolution. He is also the vice chair of the International Construction Projects of the IPBA. He is empaneled with the Beijing Arbitration Commission and Investor Grievance Redressal Committee at MCX Stock Exchange. He is also a fellow of the Chartered Institute of Arbitrators, London, and secretary of the Chartered Institute of Arbitrators, India branch. With this, I request the chair to please take over.
Okay, thanks, Radhika. I'm not Zelensky, who was a comedian who became the president of Ukraine. I was introduced as a person who has acted in many films. So I'm not an actor to start with. So whatever I did in college and just after college by acting in one film, in which I never wanted people to know about. So at the time of my retirement, somebody found out and then they started saying I'm an actor. I would love to be known as a good lawyer and a judge, not an actor. In any event, that's not relevant for this. See, the topic is corruption in arbitration, knowing the unknown. So it's a hard task for the speakers to speak about something which is unknown. So it might be difficult for them, but let's see how they're going to deal with this difficult topic. The other challenge for the speakers is to keep you awake after a sumptuous lunch. The topic is interesting, I'm sure. They're going to keep you awake. Corruption includes bribery, fraud, extortion, cartels, abuse of power, embezzlement, and money laundering. Corruption creates business uncertainty, lowers investment levels, and prevents the market from operating smoothly. It undermines development by disturbing the rule of law and weakening the constitutional foundation upon which economic growth depends. Corruption is an insidious plague that has a wide range of corrosive effects on societies. It undermines democracy and the rule of law, and it leads to violations of human rights. Corruption would start off even before the contract is entered into, and it is all pervasive during the period of the contract, and even after the dispute is settled during the stage of enforcement. It's exactly 60 years when a jurist from Sweden, Judge Lagergren, refused to decide a dispute where there were issues of corruption on the ground of bonus mores. There was a contract that was entered into between some contractors with Argentina, and the contract was for payment of 10% as agency fees. The claimant said that this 10%, which has to be paid to me, should not be restricted to one project, but it should be for the other projects as well. And that contract contained a portion of money that had to be paid as bribes to the officials. Judge Legal said that these people who have approached him have forfeited the right to ask for assistance from the machinery of justice because it's a case of corruption, which he thought that he cannot arbitrate upon. That was an award passed in ICC case 100. We have come a long way from 1963. The House of Lords deciding a case in Fiona Trust, it spoke about the concept of separability, the presumption of separability, and merely because there are allegations of corruption in the underlying contract, the arbitral clause would still survive, and the arbitrator would get jurisdiction to decide the disputes. When it comes to this country, initially, the law had been that matters of fraud and corruption are not arbitrable. These are issues which have to be tried only by a civil court because there was need for evidence. There was also a need for the judge looking at the complaints in a different way in a court of law. Immediately after that judgment came, the Law Commission, which was headed by Justice Shah, examined the need for a change in the provisions of the Arbitration Act. He submitted the 246th Law Commission report, in which he recommended an amendment to Section 16 of the Arbitration Act. He wanted insertion of Clause 7 in Section 16, giving jurisdiction to the arbitrators to decide even complicated issues relating to fraud and relating to corruption, bribery, etc. Thereafter, the Supreme Court held the judgment delivered earlier on non-arbitrability of corruption and bribery to be bad law. And the Supreme Court went on to deal with these allegations of corruption by saying that these can be subject matter of arbitration. Justice Nariman, in one case, said that there are two tests for deciding as to whether allegations of fraud are arbitrable. He said the first test would be whether a plea of fraud percolates the entire contract and above all, the agreement of arbitration rendering it void. And the second test, according to him, is whether the allegations of fraud touch upon the internal affairs of the parties in turn, having no implication in the public domain. The panelists are going to deal with a variety of issues, and I had an opportunity to speak to them as to what they're going to tell you about the unknown. But there are a few issues which they might not be dealing with, so I thought I'll just speak a few words on 2 or 3 aspects of corruption. There are corruptions in myriad ways. When we talk of corruption of parties, indulging in fraud, bribery, etc., you also have witnesses. In exit arbitrations, you have the state making complaints about corruption of their officers. When it comes to the arbitrators themselves indulging in corruption, it can be in 2 ways. Corruption can be active corruption. It can also be passive corruption. There can be corruption in the nature of monetary rewards. A quintessential example of corruption would be both actual and future payments that may be made to the arbitrator for delivering an award. There might be non-monetary awards, which include any form of other compensation, including the prospect of future arbitral appointments. How do you find out? And how do you prove these methods of corruption amongst arbitrators? A few ways of presuming passive corruption would be unexplained payments to an arbitrator in relation to an arbitration, or non-disclosure of significant business dealings with a party. There is this immunity of arbitrators, which Nusrat would be dealing with. But at this stage, I should tell you, ladies and gentlemen, that I do not know of a case where there were allegations that were made against arbitrators and the matter having been taken to court. On some research, I found that a Peruvian judge had convicted and not convicted, had sent certain persons to jail before trial, 14 of them for having accepted money from Brazilian businessmen. This is the only case where I saw the arbitrators being sent to jail, but here there's a protection. I leave it to Nusrat. I don't want to step on your toes about when you speak about this arbitration. Another aspect which I thought I would touch upon would be the position relating to Section 34, when an application is filed for setting aside an award. What happens when fraud is taken as a ground? The limitation that is prescribed in this country is 90 days for setting aside an award. And there's no way that an application under Section 5 of the Limitation Act can be filed asking for extension of time. The question would be, matters relating to fraud are unearthed much later. According to the provisions of our Contract Act, fraud has been defined. Any sort of bribery, misrepresentation, everything comes under fraud. And all of you know that the House of Lords, long time back in Lazarus Estates, said that fraud unravels everything. It vitiates judgments, contracts, and all transactions. The Indian Supreme Court and the High Courts follow the same position, say that fraud unravels everything. But then what would happen if a person comes after 90 days and then says, oh, I just came to know that there was some fraud in the initial agreement, and thereafter what happened to the arbitration, so please condone the delay. There was a case which came before the Supreme Court, and the Supreme Court, on an interpretation of the Arbitration Act and the Limitation Act, said that there is no way that 90 days period can be extended. The Singaporean law is the same. There is no extension for filing applications under Section 34, even in cases of fraud. There are certain jurisdictions where limitation is extended, namely Malaysia, New Zealand, and Ireland, where in cases of fraud, a party can go to court and then say, please extend time. I came to know of it much later. But the position appears to be that domestic legislations can relax limitation, and I think it is right time for the legislature to consider extension of time in cases where there is fraud. The Supreme Court was looking into the law as it is, and then the Supreme Court looked into Section 17 of the Limitation Act, which says that if there is fraud, the date of knowledge can be taken into consideration in matters of other cases. But I also looked into Section 29 of the Act, which says that if there is a special act prescribing limitation, that would prevail and not the Limitation Act. So the interpretation by the Supreme Court on Section 34 was, you look into Section 34(3), the language is mandatory. So according to Section 29 of the Limitation Act, there is no way that there can be an extension of time under Section 34(3) as it stands. Now, with these short words, I would request Sapna Jhangiani, analyst, to address you. And what we would do is, the three of them would speak. I might have a few questions to pose to them, and thereafter we'll open it to the house to shoot questions. Thank you.
Well, I've switched it on now. Can I just say how wonderful it is to be here as part of the inaugural Delhi arbitration weekend. Now, unlike Justice Rao, I don't have even one film under my belt, so for me, this is as good as it gets. But really, it's both a pleasure and a privilege to share this beautifully decorated stage with my co-panelists, and thank you to the organisers, and in particular Nusrat, for inviting me. One caveat, I of course express here my very personal views and not the views of the Attorney General Chambers of Singapore, for whom I am not speaking today. The topic I'm going to talk about is the burden and standard of proof for proving allegations of corruption, and really focusing on the standard of proof. Before we look at the standard of proof that is normally applied to allegations of corruption, I think it's probably worth stating as a starting point that although there's usually consensus that a party raising a claim or a defense bears the burden of proving it, and that's found in the UNCTAD rules. It's not found in any other rules, so far as I'm aware, but it's pretty much accepted. It's a surprisingly rare arbitration award that explicitly addresses what the standard of proof is that's been applied. I've probably been involved in perhaps over 100 arbitrations as either arbitrator or counsel, and I can only recall offhand one case in which the standard of proof was specifically addressed. I think it's usually assumed that the balance of probability applies. I think usually the standard of proof that is applied is that of the substantive law governing the contract, but it's very rarely addressed. It's not entirely satisfactory, but that's a starting point. And as we get into the very thorny issue of corruption, you can see that with that as your starting point, it's not 100% clear to tribunals what the standard of proof is that they should apply. I think the second starting point that's worth mentioning is that deciding whether or not allegations of corruption are proved is a very uncomfortable area for arbitral tribunals in both commercial and investor state arbitration. And the principal reason for this, in my experience, is that arbitral tribunals are most comfortable deciding key issues on the basis of documentary evidence. They're loath to make key determinative findings based explicitly on either witness evidence or adverse inferences, even if they're influenced by these behind the scenes. But the challenge we have, of course, is that corruption is almost always proved through either circumstantial evidence from which you draw inferences or witness evidence. It will be a very rare case where a document directly proves that corruption took place. So rather than being able to rely on direct evidence, a tribunal needs to draw inferences from all the evidence on the record to assess whether or not the corruption took place. And they'll also need to assess very carefully the credibility of the witnesses who are giving testimony on the corruption allegations. This is venturing very far outside their comfort zones. And at the same time, an allegation of corruption is an extremely serious allegation to make. I think in practically all jurisdictions that I can think of course, it's a crime. So for this reason, arbitral tribunals have applied a higher standard of proof than the balance of probabilities in some instances. They've applied, some of them, the standard of clear and convincing evidence. Others have applied a standard of beyond doubt or beyond reasonable doubt, so the criminal standard. Now, in a paper several years ago, Constantine Partisides, who unfortunately can't join us in this discussion today because I think he's in the other session that's taking place at the same time. He highlighted that applying a higher standard of proof for corruption allegations leads to the paradox that an allegation which is already difficult to prove, because essentially what we're talking about is behavior that is concealed very carefully, becomes even more difficult to prove, perhaps even impossible to prove. So he advocated a threefold approach to address this problem. Firstly, he said the balance of probability standard should apply uniformly. Secondly, once prima facie evidence has been adduced of corruption, then an evidentiary burden should be raised on the opposing party to show, with evidence, why the allegation of corruption is not made out. And if that evidentiary burden is not met, then there's nothing on the record to match the inferences suggesting that corruption occurred, and the tribunal may have no option but to conclude based on those inferences that the corruption took place. The third point he made is that it should be accepted that facts can be proved even on inferences. Now, this proposal, in my view, has much to recommend it. If we just look at the standard of proof that should apply, applying the balance of probability standard, regardless of the nature of the allegation, has a certain simplicity to it. You have to consider it more likely than not that something occurs. You apply the same standard of proof uniformly. You don't have to carve out allegations and apply different standards of proof. We all understand what the standard of proof in particular means. But by the same token, we all understand what level of certainty is required by the beyond doubt or beyond reasonable doubt standard. However, it's far less clear what the clear and convincing standard requires. Really, the clear and convincing standard refers to the quality of the evidence required. It doesn't refer to the level of certainty required on the fact finder. And I think that it's this clear and convincing evidence standard which is increasingly applied, certainly in investor-state arbitration, which is the body of awards that I'm drawing on for the analysis today because they're the awards that are most freely available. That's emerging as a really popular standard to be applied when assessing allegations of corruption, but I think there are real problems with it. The lack of clarity in the clear and convincing standard is well illustrated by a recent decision of the Singapore Court of Appeal in Sannam and Laos. Now, this is a long-running dispute between casino investors and the government of the Lao People's Democratic Republic, which I shall simply refer to as Laos. It's been the subject of many decisions before the Singapore courts, many arbitration awards. This particular Court of Appeal decision concerned whether or not two investor-state arbitral awards made between the claimants and the respondent states should be set aside. Now, one of them was an ICSID award, one of them was under the auspices of the PCA, but they were essentially identical. They were claims brought by two different claimants connected under different treaties. There had been allegations of corruption made by Laos against the investors in relation to the investment that the state claimed disentitled the investors to treaty relief. The parties agreed that Laos bore the burden of proving those allegations, but there was a big dispute about what standard of proof should be applied. The claimants said that there should be clear and convincing evidence, and no doubt on the part of the tribunal. The respondent state, of course, which bore the burden of proving the allegations, said that the standard should be the balance of probabilities. So what did the tribunal do? Well, the tribunal said that there should be clear and convincing evidence on at least some elements of the allegation, but not all of them. And An assessment must then be made of which of the elements of the alleged acts of corruption had been established by clear and convincing evidence, and which elements were left to reasonable inference. And then ultimately they had to decide whether the alleged acts of corruption were established to a standard higher than the balance of probabilities, but less than the criminal standard of beyond reasonable doubt. So somewhere in between. Now, the Singapore Court of Appeal said that the arbitral tribunal's formulation of the standard of proof was, and I quote, not entirely clear. And I think many of us here may have some sympathy with that view. However, it wasn't found to be a ground to set aside the award. Now, the court explained that the level of certainty required by the balance of probability standard is very clear, as is the level of certainty required by beyond reasonable doubt. But in between that, there really was a grey area, and it wasn't very clear. The most interesting part of the judgment for me is that the court cited an Australian case from 1938, perhaps because the international judge, Justice Robert French, was on the bench, no doubt has a very in-depth knowledge of Australian case law. And in that case, Dixon J. said that the truth is that when the law requires the proof of any fact, the tribunal must feel an actual persuasion of its occurrence or existence before it can be found. It cannot be found as a result of mere mechanical comparison of probabilities independently of any belief in its reality. So there you have it in a nutshell. As a fact finder, either you believe that something happened or you don't. And I think part of the problem we have is that judgments and awards, of course, they're always written like mathematical equations. You apply the rigorous analysis to the law and the evidence, and the mathematical result is what you come up with. But that's not really how the real world works, and that's not really, in my view, how the art of persuasion and being certain of something as a fact finder actually works in practice. Most importantly, you may be persuaded that something is proved through a mere preponderance of inferences together with witness testimony. Now, in the criminal law, we do this all the time. I'm perhaps one of a small number of arbitration practitioners that has experience of criminal law, including corruption, and I think we could learn a lot from the tools applied by judges deciding criminal cases, certainly in Singapore, which is the jurisdiction that I'm most familiar with in terms of criminal law. So in Singapore, where a judge is asked to convict someone in a case where there are two competing and mutually exclusive testimonies, which can happen quite a lot with corruption, there'll be no documentary evidence. There'll be somebody alleging that they were offered or paid a bribe, and there'll simply be two witnesses with competing testimonies. The judge, looking at an uncorroborated witness testimony, must find that the witness's testimony is unusually convincing based on the totality of the evidence. How do they do that? They look at the witness's demeanor. They look at whether the witness's evidence is both internally consistent and externally consistent with all the evidence, including circumstantial evidence. And they make an assessment of the consistency of the defense's case. Frankly, all this analysis involves, when you look at it fundamentally, is looking at the inherent plausibility of one account of events when compared with the opposing version of what happened. And we're back to the postulation of the Singapore Court of Appeal. As a judge, either you believe something happened or you don't. Once an allegation is raised under the criminal law, then there's an evidential burden raised on the defense to rebut the allegation, otherwise an adverse inference may be drawn. I think it's a bit unfortunate that we call that an evidential burden. I think the semantics are a bit unfortunate. Frankly, all we're talking about is a desirability of adducing evidence to support your case. Otherwise, adverse inferences will be drawn against you based on the other evidence on the record. So just to conclude, There are tools out there to help tribunals in assessing whether purely witness and circumstantial evidence can prove that a very serious allegation is made out. I think we have much more work to do in presenting these kinds of forensic tools to arbitrators, and we need to present them in a way that undermines the assumption that only direct evidence, such as documentary evidence, which we as arbitrators are most comfortable with, can lead to a finding that a serious allegation such as corruption has been proved. My preference would be to do away completely with the clear and convincing standard. But both witness and circumstantial evidence, or inferences, if I can use that as a paraphrase, can, if weighed and assessed carefully, even lead to a finding beyond reasonable doubt that, that corruption has actually taken place. So what's required is arbitrators grappling with these issues head-on, not shying away from them, even though making key findings without documentary evidence is firmly outside their comfort zone.
Thank you, Sapna. In this country, as we understand, the standard of proof is twofold. In a criminal case, the charge of corruption has to be proved beyond reasonable doubt. And in a case where there are civil consequences, it is preponderance of probability. You spoke about clear and convincing evidence, and that being somewhere in between the two. As I understand, there are views and views, especially here, two views. As some people say that as corruption is connected to a crime, it should be proved beyond reasonable doubt, because you leave it to the arbitrators sometimes to initiate sua sponte, which will be dealt with by Francis. What would be the standard for even initiation of proceedings by the arbitrator, because he can't initiate proceedings on suspicion. There should be some prima facie evidence, and then come to this standard. Can you tell us what was the principle of law which was relied upon by the respondent in Sanu versus Laos to argue that the investor was disentitled to investment protection because of alleged bribery and corruption?
That's actually quite an interesting part of the judgment for us common lawyers, because what the investors said in those cases was that the investors, what the respondent state said in those cases is that the investors had not come with clean hands to seek treaty relief before the tribunals. And what the tribunal said was that the clean hands doctrine is a metaphor employed as a defense to equitable relief in common law jurisdictions. But they said if you put aside the label, serious financial misconduct by the claimants is incompatible with their good faith obligations as investors in the host country. And ultimately, they interpreted the clean hands argument as a part of the principle of international law that's read in these investments treaties, that there is an obligation of good faith on investors.
I've touched upon fear not trust and the judgment of the House of Lords relating to the doctrine of presumption of separability. Can you throw us some light on this doctrine in terms of Article 16 of the model law?
So I don't want to get too much into what Francis is going to talk about, which I think is going to touch on at what point do you raise corruption allegations? Do they go to the merits or to jurisdiction? But I think that certainly if we're talking about a commercial contract, then corruption generally doesn't affect the jurisdiction of arbitral tribunals, because under the doctrine of separability, the arbitral clause has a separate existence from the main contract and in principle will remain valid even if the main contract is null and void. I think it's different in the regime of investor-state arbitration, though, where allegations of corruption are based in the context of both jurisdictional objections and also as substantive defences to the merits, as I touched on in relation to the Sanam and Laos case, where the unclean hands doctrine was relied upon.
Party autonomy is of paramount importance to an arbitrator exercising his jurisdiction, but there's always a public policy that would also come in. So can a party-chosen law be overridden by the laws of public policy at the place of performance?
If we talk about this in the context of corruption, I think we can talk about it theoretically, and I think it's an interesting question, but I think in reality, I can't think of any domestic law in any jurisdiction that wouldn't provide that corruption was illegal under domestic law. So there probably wouldn't be any conflict in reality between what domestic law says about allegations of corruption and what public policy would say. But I do think that in theory, arbitrators do have a duty to issue enforceable awards, and if they consider that an award may be set aside or not enforced because of the public policy in any court before whom an application may be made, then they may wish to raise public policy in the award, even if it runs counter to the party's applicable law, specifically in the context of corruption. But I do think this is more likely to be an academic point, perhaps, and something that we'll see in practice.
Thank you so much. Sapna? Francis?
Thank you, sir. Thank you. I've been asked to touch on two topics. One is whether these allegations of corruption would go to merits or to jurisdiction, as Sapna has just touched upon. And second, whether, corruption takes two hands to clap, two or more hands to clap. So if a tribunal realizes that the stench of corruption in a particular case is strong, but neither party has raised it, would the tribunal have a duty to look into it, as they say, either carry out an ex officio investigation or to look into it sua sponte? So those are the two questions I will look at. And looking around the room, I see very eminent faces, and I suspect many of you would know more about these two questions than I do, so I'll be short. So as not to break or be in violation of the edict, do not try and teach your grandmother how to suck eggs. So on the first question, whether it goes to merits or jurisdiction, I think we all can agree that, of course, it goes to merits. If there's a contract in dispute, allegations of corruption would go to the root of the validity of the contract and therefore affect the contractual rights of the parties. But in international commercial arbitration, it is very difficult to think of a situation where corruption will go to jurisdiction. I think, Judge, I know of one case, although I think it has not been reported or the arbitrator has not been charged, but there's a very strong suggestion that an arbitrator in the AIAC, formerly KLRCA, had actually been bribed by the party. And the last I heard, it was under investigation by the police. But that's about the only case that I know in the region. But apart from a rare situation like that, it is difficult to see how allegations of corruption will go into jurisdiction in international commercial arbitration. So it will invariably go to merits. But in ITA, investment treaty arbitration, I think this is a point that Sapna touched on. It will go to jurisdiction, right? Because every treaty will require that you make an investment as a prerequisite. And most treaties will say that the investment must be made legally in accordance with the laws of the state, the host state that you're going after. And it is clear that even if the treaty is not clear and it doesn't say the investment must be legal or comply with the local laws, international tribunals will import that condition implicitly, either on the grounds of clean hands or as an implicit condition, like an implied term in a condition, or alternatively international public policy. So they have all these various buses that they will drive through the wall to bring that condition in. Now, the only thing I want to say is, and this is also a point that Sapna touched on, the timing is important. In order to go to jurisdiction, the corruption must have occurred at the time the investment was made. Because if the corruption occurs at a subsequent point, then it can only go to merits, not to jurisdiction. The last point I want to make on that issue is, of course, if the investor can show that the state knew, and many a times the corruption is such that organs of state or individuals in the state, part of the government would have been privy to it, and if that's the case, then you can unleash estoppel in a unique form against the government. If the government or members of the government, arms of the government had known about it and endorsed the investment at the relevant time nevertheless. Now, coming back to the other question, which is, where both parties have not raised the issue of corruption, but the stench fills the room. The question that's been debated by jurists, I didn't find this debate particularly interesting, especially at a time like this after lunch, but let's just go through it very quickly. The question is, does the tribunal have a duty to investigate sua sponte, where that stench is coming from? And I think the better answer is that the arbitral tribunal should look into it, right? Rule of law. Corruption goes to the heart of rule of law and also threatens the very, if the arbitral tribunal were to ignore the stench, then it goes to the root of the integrity of the arbitral process itself. And more than that, it may result in the award being threatened, if that is raised. If it can be shown, for instance, if the arbitral tribunal turned a blind eye to what would otherwise have been very obvious, right? So I think the better view is that they should go into it. But just on the point of arbitrability that Justice Rao talked about, I think don't assume that all of the modern world today would accept that corruption is arbitrable. One is reminded about the 2000 decision in Pakistan, the Supreme Court of Pakistan, Hapko and Wapta, I think, where by a 3-2, the Pakistani Supreme Court held that corruption is not arbitrable. Now, there's been some doubt cast in 2002 in Pakistan by the Society General decision, but I think we need to assume, we cannot assume that apart from the case that Judge 1963 case, the 60-year-old case that Judge referred to, that one cannot assume today that all civilized nations accept as a fact that corruption is arbitrable. Back to you, Judge.
You're right in referring to the Pakistan judgment. I think Pakistan, which still follows the old Arbitration Act of 1940, they haven't made amendments to the Arbitration Act after the Considerable Model Law has come. They still follow this principle of matters relating to corruption and bribery having to be investigated only in courts. Francis, I wanted you to tell us as to whether there is a duty of the arbitrators to report corruption to the concerned authorities. What is the position in Singapore? And what would you subscribe to? Let us take, there are allegations of corruption made insofar as parties are concerned to an arbitration before the arbitrator. Whether he quietly goes ahead and then tries to resolve the civil side of the dispute. But would there be a duty on the part of the arbitrator to report to the authorities to have a criminal investigation done?
Again, around the world, there are many jurists sitting around debating an issue like that. And so some say, no, you shouldn't report because your remit is confidential. Arbitration as a process is confidential, it is confined, and by reporting, you're in fact making it public. You shouldn't do it. Others argue that there is this duty, which sounds pretty good, to the arbitral community at large to report, malfeasances. But I think the better view really is, what do the relevant statutes, codes, or regulations tell you to do? In Singapore, for instance, Judge, there is no obligation to report corruption. Now, there is if you notice that your neighbor is hammering the other neighbor across the road, then you have a duty to report. Sapna knows that as a member of the Attorney General's office. but there is no obligation to report corruption. So I suppose if you're seated in an international commercial arbitration, if you're seated in a seat that requires or compels you to report, then obviously you have to. Investment treaty arbitration, by definition, unless you have a Stockholm or Singapore or Hong Kong seated arbitration, invariably there would be no seat. But again, if there are applicable rules that would apply to you, and those rules prescribe that you need to report, then I would say yes. So I think, Judge, my answer would be it all depends on the applicable rules, canons, codes, statutes.
And let us take a situation where there are parallel criminal proceedings when an arbitration is going on. In this country, there was a lot of debate as to whether the civil proceeding should be kept in abeyance or whether we can go to the criminal court and tell them that the civil court or the arbitrator is engaged with this matter, so we don't proceed with this. Is there a duty of the arbitrators to stay the proceedings till the criminal courts decide the issue?
So, Judge, I must say that your questions are way more thought of than what I initially presented. No, so this is a big conundrum, right? Should a tribunal, faced with parallel criminal proceedings going on, and at the same time the allegation of corruption is before you, should you stay your arbitration now? I think the hardened arbitrators in the room would know that instinctively they will, have a gut-wrenching resistance to any attempt to stay or postpone or derail the arbitration. Speed is the essence in arbitration. And, one will argue that in the arbitration, as Sapna has spent quite a bit of time, you're looking at the corruption and its impact on contractual obligations between parties inter se is very different from the exercise in a criminal process, which is to see whether X and Y should be sent to the dungeon. But I think the matter is not so simple because, one, if I'm the party raising corruption, I'm a private party, obviously my resources are limited. And if there is a parallel criminal proceeding going on at the behest of the state, a party that Sapna would be very familiar with, although she says, don't link me with the state today because I'm in my personal capacity. But obviously, that party may say, I want to rely on what the apparatus of the state and the evidence that it has uncovered in these parallel criminal proceedings, which I don't have access to, or I don't have the kind of powers the state has. But I'm saying there is corruption, right? Now, obviously, the state thinks so. Otherwise, why are they prosecuting, right? And so please, this is the very issue you're going to decide. Please stay the proceedings. Now, I think that gets a little bit into a natural justice. You can see how that could get into an accusation at a later stage that the tribunal had shut its mind to potential evidence that could have been utilized post a conviction or whatever in the criminal proceedings. Indeed, the party might argue, even if the accused persons are acquitted in the criminal proceedings, there the test is beyond reasonable doubt. No wonder they failed. But if you apply my test, in this case, which is a lower test or even an intermediate test of clear and convincing, the evidence that was led by the state would pass that test. All these nice arguments are going to be made. So the case for staying, it's not a trivial case. Add to it the consideration that if you carry on with your arbitration, even without the benefit of the evidence there, you risk inconsistent decisions. You say, even at a lower standard, there is no corruption, and ultimately those guys beyond reasonable doubt are all sent to the dungeon. You have a problem there, right? So I think this is actually a deep conundrum, Judge. You might share your perspective as to how you would rule if you were sitting on the bench still, but back to you, Judge.
I agree with you that acquittal by a criminal court would not be to the benefit of the person who is facing charges of corruption in a civil proceeding. The same applies to an arbitrator. So the arbitrator can still go ahead and on the basis of evidence and by adopting a different test, which is the preponderance of probability, can still hold a case against the person who was facing the allegations, notwithstanding an acquittal by the criminal court. I just want to share with you the position as it stands in this country. If there is a parallel proceeding, a civil proceeding where some allegations are made of corruption, and there's a parallel criminal proceeding which is going on, normally a person who is facing allegations in a civil court approaches the civil court and seeks stay of the proceedings, because he would say, I don't want to reveal anything which might affect my trial. So that is one area where the courts might think in his favor and think of staying a civil proceeding. But my view is, merely because there is a parallel criminal proceeding that is pending, there's no need for the arbitrator to stay the arbitral proceedings. I agree with you. Thank you so much, Francis. Now, Nusrat?
Can I?
Yes.
Point? I perhaps omitted to mention, in the Sanam and Laos case, as well as the unclean hands doctrine, the respondent state also said that the investors' alleged corruption was against transnational public policy. And if you look at the cases, there's increasing consensus that corruption is against international public policy. Quite often what you see relied upon is the United Nations Convention Against Corruption. And I just raise that because I think it's going to become increasingly difficult for arbitrators to resist a suggestion that they should investigate allegations of corruption when they see very clear red flags. Because of this growing consensus, it's becoming almost ubiquitous. So if you simply ignore them, we even have, I think, an IBA report that actually sets out what red flags are. So there's a confluence of factors, and I think it's going to get harder and harder to ignore them.
Yes.
Thank you. Thank you, Justice Rao. Ladies and gentlemen, first let me thank the organizers for allowing me to be on this panel, esteemed panel in this august company. Now, when you speak last, a lot has already been said, leaves little for me to speak. But I'll touch upon two topics. I think in an arbitration, especially in our country, where over the last 3 decades, we have come to a point where today we are quite proud of the way the arbitration ecosystem is progressing. And today's subject matter, corruption, is quite critical, because any injection of that at this point could lead to a debacle to the whole ecosystem. So I think this is a very critical topic, a very difficult topic to deal with. But let us understand what the law at the moment is in India, and what does it mean for the practitioners. Today, today we all know that arbitration is contract-based, so it's very difficult to apply any anti-corruption laws to an arbitration versus when you apply it to an arbitrator. But what it does definitely, and immunity is critical, because without that, you do not provide any safeguard to an arbitrator. Today, under the Indian Arbitration and Conciliation Act, we have Section 42B, and it's not the only jurisdiction in the world that has provided in the legislation a provision of immunity for arbitrators. In India, we have, of course, 42B. England, there is Section 29(1). Singapore, Section 25 and 25A. Australia, Section 39. And then there are several countries which do not have any specific section or have incorporated anything in the legislation. But where they follow where they follow predominantly the precedents, the case laws which exist in the country for ensuring that there is immunity provided. Popularly, of course, there is a consensus that arbitrators would be provided the immunity to allow them to conduct their arbitration and safeguard their independence. But surprisingly, I was surprised myself, the US was not the same. US, in fact, the case goes back long way back, Jones versus Brown. There, the arbitrators were exempted even if they were accused of acting fraudulently and corruptly. But of course, that law has changed with Huzak Tunnel Dock and Elevator Company O'Brien, where of course arbitrator immunity is now is limited to the limited and it's not unlimited, which is the right thing. So therefore, you see that there are two ways arbitral immunity has been provided. Arbitrators have been provided immunity, and that is either by incorporating within the legislation of that country or by judicial proceedings. In fact, I must point this out, under the Japan Arbitration Act, when a person is appointed as an arbitrator, he demands or promises or accepts a bribe in relation to the duty to assume with agreement to do an act in response to a request, imprisonment and with labor of not more than 5 years shall be imposed in the event of appointment. So here there is a criminal provision which has been incorporated. So I think already, Francis, you've dealt with the issue that what do you do when the question arises whether the arbitrator should report of an act of bribery or corruption to the authorities or not. I mean, that's a matter of great debate. Now, it really is still undecided the right thing to do. Of course, we heard Justice Rao, the fact that even if you do report and there are proceedings, criminal proceedings which are initiated, then in that event, the tribunal can still continue and proceed with the arbitration. But of course, it has its own pros and cons to do that. But I think the right thing to do, I think, without doubt, I think we heard Francis or Justice Rao say the same thing, that ultimately, if there is a corruption and it has to be called out, because if you do not call that out, it would lead to a situation where the tribunal is tainted, and I think the thing what will be left behind would definitely not be good for the ecosystem for any country, especially in India. The next topic which I would like to touch upon is on the question of what can arbitral institutions do, because this particular session has been powered by the Chartered Institute of Arbitrators. I think institutions, the bar, I think all the people who are involved in arbitration can do much. I think there is, especially when I talk about the Chartered Institute of Arbitrators, where people from all different walks of life become members. There are about 18,000 odd members today. And they have a professional code of conduct and ethics. So they have, when you become a member, now this is an institute which is quite unique because many of you would of course be members here, but the fact that it provides an accreditation, so you become an associate, a member, or a fellow, or a chartered arbitrator. And you use those nominals when you're describing your designation. So once you become a member, you sign up to the professional code of conduct and ethics. So tomorrow, if you are acting as an arbitrator and if somebody alleges anything against you, then the institute is bound to investigate. So it has a long process set out following the principles of natural justice, where in that event, it can suspend you, it can also expel you, which of course nobody would want it because it directly affects your ability to get your next appointment as an arbitrator. So institutions, we have LCIA, we have ICC, which have incorporated again articles within their rules to deal with the aspects of corruption as and when it arises. So the institutions quite clearly have a large role to play to protect this ecosystem from any kind of corruption. I'll pause for the moment now, just
Thank you, Nusrat. You spoke about Section 42B of the Arbitration Act of 1996, which was introduced in 2019. See, this is on the basis that the judges should be given some immunity because they might be facing some frivolous allegations by a disgruntled party. That's the reason why immunity is given to them, and as arbitrators discharge quasi-judicial functions, as we call them, so they also need the immunity. But the immunity that is given here is for anything done by the arbitrator in good faith.
Correct.
So correct. Corruption and bribery, fraud, all these are not in good faith. So what is the immunity that is given?
Good question. Good question. So I'll go back to as to why the 42B was brought. The history is that the Sri Krishna Commission, in its report, had suggested that such a section be brought in. So they decided. So what the Commission had said that we should adopt a clause that provides for immunity unless the act of omission is shown to have been in bad faith. Now, good faith is not defined anywhere. Bad faith is not defined anywhere. But if you look at the General Clauses Act, good faith is defined. Now, what is good faith? Now, of course, these are all terms which is always very difficult to interpret. What the General Clauses Act says defines good faith as something that is done with honesty, irrespective of whether it is done negligently or not. So I think the focus has always been, when you are acting as an arbitrator, is of course on the civil side. I think the criminal part, the aspect has been, I think we really don't get much guidance on that anywhere, except the fact that nothing stops you from going to the police and making a complaint and using the Indian Penal Code. But the fact is that at least to the extent that the arbitrator is protected from the civil and tortious liability, he at least gets that protection under the good faith, if nothing more. I mean, I don't know, I'm sure I'm answering.
And I also want you to tell us whether there are any anti-corruption laws in India, assuming there is an arbitrator who indulges.
According to me, there is no at the moment there is no anti-corruption laws in India, but I think I'm not sure. I would like to understand if whether tomorrow an arbitrator can be caught under the PMLA for using ill-gotten money.
There's a distinct possibility.
Huh? Sorry?
I said there's a distinct possibility.
Yes.
So, see, in any event, Prevention of Corruption Act is not applicable because the arbitrator is not a public servant.
Arbitrator is not. Though the word arbitrator is used in small caps in the Prevention of Corruption Act, but it surely doesn't mean the arbitrator under the contract. Yes.
So one last question. Can you tell us whether there are any red flags or indicators which help the arbitrators in identifying corruption?
Oh yes, I think there are several guidance. I think institutions tend to provide these red flags, and I think any practitioner should be well aware of it. I mean, red flags. Of course, as all seasoned practitioners, you tend to get a sense of the room when you enter it, and the arbitration progresses. Of course, the client will always feel there is a bias going on if the arbitration is going against him. Keeping that aside, there are red flags, and I think these red flags could be there's an unusual delay by arbitrators in conducting these arbitrations. There are reasons why he's delaying it. I mean, where one party wants the arbitration to continue forever. Then of course, conflict of interest, normally, which you're supposed to disclose under Section 12 of the Act. I mean, if that does not happen, and there are many cases where you would come to know post his appointment, and the arbitrator may have not disclosed it. of course, then this is a clear sign again that there could be a scenario of where a doubtful, there could be this could be a case of corruption. Unusual secrecy, dealing with the party, writing to the party separately, not marking it to the other parties involved, unusual communication. And of course, one of the things is taking up applications which are out of turn, passing orders on those applications which is not required. I think we could all list out 20 different kind of things that we have seen. But yes, they have to be called out, at least from my experience. My suggestion is that some of the councils, I feel, many a times tend to take a back step, not wanting to alienate the tribunal. But I would suggest that in an arbitration, you need to call these things out, because otherwise it disturbs the ecosystem.
Thank you so much. I'm done with my questions to the panelists. Before it's your turn to ask questions, I will ask a question to all of you. Anybody who can answer. In light of what Nusrat said, would bias amount to corruption? Can anybody answer? Apparent bias of the arbitrator? Allegations of bias against the arbitrator? Yes, can anybody give an answer, please? But is that corruption? Does anybody have a different view? Yes? Can anybody pass on the mic, please, to them? Just 1 minute. David is there. You want to speak, David? Yes. Can you introduce yourself? I can introduce you. David Brynmore Thomas from 13 and Essex.
And it's my pleasure to be your colleague. I don't think that bias, whether apparent or actual, is in fact corrupt. It is small c corrupt conduct. It is reprehensible conduct, but it is not corruption, as I think we're discussing it in this panel. It may be, and I think this is Nusrat's point, it may be a flag that leads you to conclude that there is corruption. So you have to ask the question, if an arbitrator is being biased, why? The conclusion may be because they're being given brown envelopes, although I've never seen that. But it is not corruption in itself. It is simply small c, corrupt, reprehensible conduct, my view.
I will tell you my experience with this bias. There are allegations made against even judges, why arbitrators alone. The judge is biased. Bias is, real likelihood of bias is the test that is followed in this country. Why bias? Because he has not been granting adjournments to me. Or otherwise he's harsh to me. Or otherwise he's very nice to the other side when he's arguing, he's calling him by his name and then giving him more time to argue. Can this be corruption? No. So would all of you agree with me that in certain situations,
use the mic.
He is not a professor.
He's a professor.
Oh, I didn't know that. You're right, because I didn't know that. Yes.
Biasness is rewarded with partiality and independence, but it's not corruption per se.
Yes. Yes.
Anyone can be an arbitrator. So a legal person would be very focused as to even all the guidelines. Sometimes a person, let's say, is an industry expert, he's not even a legal person. Are negligence or maybe something which has gone the foresight can lead to bias, but that would not be a corruption. So definitely they can have an overlapping feature of point, but they're not the same.
Now let's have the views of the panelists on this. Yes, Sapna?
I'm still interested
I'm waiting to hear one.
Yes, you can finish and then I'll ask the panelists.
Sorry for asking the next question. It's not corruption in the legal terms as corruption is defined, but I have another question. I agree bias is not corruption. What happens when an arbitrator just drags the arbitration on for whatever reason and earns more fees? Would that be corruption?
That's not strange, is it?
It's a question of corruption.
Then most of the arbitrators would be biased, leading to...
Corruption in the sense that Sir said, Justice Rao said, but my question is slightly different, which is corruption is defined legally. Only amount to financial corruption. What happens if an arbitrator drags it on? Any arbitrator, would that amount to corruption if the arbitration just goes on and the parties are just paying fees, professional fees? Would that be corruption, sir?
Don't know, might be. Because there was a case which came up before the Supreme Court in respect of a fee of arbitrators, where the court said insofar as domestic arbitrations are concerned, they should go by the schedule fee. They cannot force the parties to pay more than the schedule fees. One of the points that was raised there was, by ONGC, that the arbitration had been pending for more than 6 years, and there were 80 hearings, and the arbitrator said, enough is enough, now I'm going to raise, there's a single arbitrator thing, I'm going to raise my fees, whether he could do that or not. So in such a situation, can you say that the arbitrator is biased because he's dragging on the proceedings? We do not know what reason. We are not making any allegations or assumptions also. And whether that bias would amount to corruption. What do you say?
Sir, may I speak? Yes. Bias has never been considered as corruption because it develops from the nature and the society. Suppose from you develop in society, every day, every incident makes you, from certain incident, you make some bias. Suppose there is an accident and you got injured, certainly you will, in any other case when you are deciding, you have some bias here, certainly they used to, they have rash driving and my family was injured in that. So every person, it is developed by the conduct of a person.
Yes. Now, let us have the view of the panelists and then we will go for the other questions. I think we're getting stuck with bias now.
Yes. So I think hearing all of you, I'm somewhere in the middle because personal bias, I agree, would not be. But when you cross a line of bias, I would have to look up the exact meaning in the dictionary. But if you cross the bias, where you will lean towards one party to give him a favorable judgment, will that not amount to corruption? Because you're going to do that because there is some reward at the end. Now, there may not be a direct reward, but there are indirect rewards because ultimately this ecosystem is very different from the court system. I think that difference has to be understood and has to be emphasized. I feel an arbitration is we talk about autonomy, it's about private parties conducting this ecosystem with least supervision of the court. I think when the bias crosses the line, where when there is an award in favor of a party because of that bias, I think it crosses the line.
Sapna?
Just 3 quick points. The first is that bias may raise an inference of corruption, but it depends, of course, on all the circumstances and the totality of the evidence. The second point is I've been very studiously attending the previous sessions today, and I've gathered that if we have more of a move to the live transcription of hearings and witness evidence, we could have a lot less delay in arbitration hearings. I've had that experience myself in arbitration seated in Delhi, where I've insisted that we fly in transcribers to make sure that we don't have this laborious process of having the evidence and then repeating it all and making sure it's correct on the record. And the third point I want to make is this was raised in the ICC session this morning. It would be great if we had even more institutional arbitration in India and more institutions like the ICC that actually reduce the fees of arbitrators if they delay and prevaricate and take too long to get to the award. If we see more of that, I think that might be a good thing.
I just go. Panelists from the audience have said nothing further.
Any more questions? We still have another 10 minutes.
Over there, sir.
I thought there will be a number of questions and we might have to sit after 3:45.
Good afternoon. My name is Rajah. My question is that corruption could be at the time of formation of the contract and also at the time of performance of the contract. So an arbitrator dealing with corruption allegations, how would he deal on merits in both cases? Probably when it's at the formation stage, the contract would be rendered void. So in that case, what happens to the money paid under that contract? I think there's an English decision of Patel versus Mirza on proportionality. So whether that approach, the all or nothing approach, should be canvassed. And in case of corruption at the time of performance of the contract, the performance may be in a different country from where the seat is. So what law would apply in deciding corruption, and what would be the consequences and how an arbitrator would handle it?
Underlying contract? Yes.
Can I just add, though, there is this English principle that if one establishes that the contract was procured through bribery, that corruption is irrelevant to the contractual rights between the parties. So I think you need to make a distinction between that sort of, whether the contract itself, the entry into the contract was procured by some kind of bribery, or as you say, the performance of the contract.
I think the English law, insofar as the seat is concerned, David can correct me if I'm wrong. There are three laws here. One is the chosen law. You have the law of the seat, and where the contract is being performed. According to English law, if there is any connection of any of these three, English courts get jurisdiction. David, am I right? Yeah, I think you can you give an answer to whatever he has asked?
Yeah.
I wish somebody hadn't said that I was a professor. As I understand the question, it is if the corruption has taken place, is that the question? If the corruption has taken place elsewhere than the seat? I think the first question I would ask is, does the corruption impeach the arbitration agreement or the substantive contract, the Fiona Trust point that Justice Rao identified? Because if the corruption doesn't impeach the arbitration agreement, then the arbitrators will continue to have jurisdiction sort of uninterrupted, certainly under English law. That, I think, you would judge by reference to the law applicable to the arbitration agreement. And I think you would consider then, if you were thinking about the law applicable to the corruption, I think the question of the law applicable to the corruption itself, in my view, just as a first reaction, would be that would be a question of the law at the place where the corruption took place. And you would then import that into the arbitration, in my view, as a question of fact. So if in a country it was corrupt to simply give a cup of tea to a party, then that, as a matter of fact, once you tested it against that law, would be a corrupt act, and you would then have to import that into the substantive arbitration. That's my first blush view.
Thank you. Thank you, David. Yes?
And my second part of the question was on the damages part. What happens to the money paid there? Does it become unjust enrichment for the person who's taken the bribe, or it's restitution?
Yes. Yes, any other? Yes, Vaibhav?
Yes, sir. My question is a follow-up question. At what stage would this...
Can you introduce yourself? I know you, that's why I called you, Vaibhav.
I am Aditya Vaibhav Singh. I am an advocate on record in the Supreme Court of India. My question is a follow-up question. At what stage would this question of corruption be decided by the tribunal when this objection is raised? At this specific juncture, when the seat of arbitration is elsewhere, the corruption allegation is elsewhere, but the tribunal is here, at what juncture in these specific circumstances of the case would be decided? At Article 16 or at the stage of the final argument?
No, I don't think you need to.
Yes, I mean, invariably, especially Pavi's question, I think the corruption would go to the merits of the claim, right? It's part of adjudicating the claim. So it should be raised as soon as possible, at the stage of the pleadings. Certainly, it would be debated hotly at the hearing. I mean, that's, unless I'm missing something, my friend. I would have thought that in the course of the arbitration, subject to this, right, if the corrupt act, for instance, was only discovered later, after the award is issued, then there's a line of cases that say you need to then, and then you're trying to either set aside the award or resist enforcement of the award, then you need to establish that, you could not have raised this point earlier as part of the merits because you were not aware of it,
I asked this question because the fine distinction which Professor David made. He said if the corruption vitiates the formation of the arbitration agreement itself or the substantive contract, so would there be a distinction at the stage of adjudication also? That is my specific question.
Is as to whether an allegation of corruption which is raised should be decided at the 16th stage or would it be at the final stage when the award is passed, if I understood you correctly. Is that what you are asking, Vaibhav?
I'm asking is it thumb rule or whether it depends on the allegation of corruption, whether it goes to the root of the appointment also.
Correct. So if an allegation is made and an application under section 16 is moved, so the arbitrator would have to decide it, is it not? And there's nothing that is mentioned in the act as such, but I don't think the arbitrator can wait and then say it's all right, I'll look into it at this time of filing, passing an award.
But an allegation of corruption that goes to the root of the arbitration agreement or the ability of the tribunal as constituted to hear it would have to be a very serious one, and that is actually quite an unusual situation.
Hence the questions. Thank you.
Can I?
Yes.
So my name is Tariq Khan. I'm the Registrar of International Arbitration and Mediation Center, Hyderabad. The question is that in your experience, Sapna and Francis, especially you in international tribunals would have seen that corruption allegations are easy to raise but difficult to prove. So first question is in relation to what is the level of proof required, though you have discussed in some depth that to what extent it is done. But what is the test as an arbitrator that you choose in a given case? And the second thing is that don't you think that there is something that in arbitration we should learn from courts in terms of flexibility, because arbitrators don't have power to subpoena or to probably summon witnesses because sometimes for corruption you have to summon third-party witnesses also, and certain documents need to be produced in red fund schedule, etc. So do you think that that kind of flexibility needs to be given to arbitral tribunal as well when allegations of corruption are involved? Thank you.
Sapna?
So for the first question, I have fortunately not had to decide allegations of corruption, whether they've been made out. So I have to say I reserve my judgment on which test I would apply, but I would certainly not be applying the test of clear and convincing evidence, because I think it's just very, very unclear as to exactly what it means. As to your second question, I understand the question to be really, should the arbitral tribunal be given more power rather than more flexibility in terms of the ability to subpoena witnesses, etc., to find out whether the allegations of corruption are proved? Now, of course, the courts of the seat, which have supervisory jurisdiction over the arbitral tribunal, may be able to assist, But of course, the relevant witnesses and documents, etc., may be outside their jurisdiction. That's the very nature of international arbitration. At the end of the day, the arbitral tribunal may want more evidence, but they simply have to take a view based on the evidence before them. In the Sanam and Laos case that I mentioned, the key alleged bribe taker, who was accused, I think, of taking almost $1 million in bribes from the investors to pay to the respondent state, was put forward as a witness by Laos. And then during the course of the arbitration, she was made a loan of $75,000 by the claimants under quite suspicious circumstances, and she didn't come to give evidence at the hearing. And so the tribunal had to make a decision as to whether or not they felt that the allegations of corruption based on the bribes that she allegedly was paid to pay over to the government were made out or not. And they found that on the balance of probabilities, based on all the inferences from the money that had been paid, the lack of explanation, the fact that she had been made a $75,000 loan at the time that she was due to come and give evidence by the claimants through a third party, all of that suggested that the allegations were made out to the lower standard of balance of probability. So I think at the end of the day, arbitral tribunals' powers are limited, even supervisory courts' powers are limited, where witnesses and documents are outside their jurisdiction. So tribunals have to work with what they've given and assess the totality of the evidence on the record, including the absence of certain evidence or witnesses from the record.
Nothing to add, sir.
Yes, we can take another question. That will be the last question because we might have to close this now.
My name is Mohit Jolly. I am an advocate practicing in the Delhi High Court. Sir, my question stems from a statement you made regarding that the arbitrators discharge a public function, or they are quasi-judicial functions which they are discharging. So shouldn't the reporting of a corruption case be an absolutely mandatory on an officer who's discharging a quasi-judicial function, and should it be left to their decision? So I take aid of Section 39 of the CRPC, which mandates that in case of illegal gratifications, the reporting of a crime is mandatory. So on that basis, shouldn't the arbitrator have an obligation to report it?
So Francis said that it all depends on the domestic law, whether you have to report or not. I will agree with you, as the arbitrators are definitely discharging some public functions of resolving disputes. If at all something comes to their notice, they might have to, or they would have to report to the authorities. That's my view as well. Thank you very much. The presentations and contributions made by the speakers today, I hope they were able to speak about something unknown to you. This is knowing the unknown. I'm not very sure, but I'm sure that at least something was spoken. As Francis was saying, all pundits are sitting here, they might be knowing more than what we know. Thank you very much, and I thank you all for engaging yourself in this very interesting debate of something about corruption which we don't want to prevail. Thank you very much.
Thank you.
Thank you, Justice Rao and the rest of the speakers for such an engaging session. And yes, we definitely have been able to unveil some of the unknowns through this session. Thank you. We'll now break for 15 minutes and we'll resume at 4 p.m. sharp.